Keep up to date everywhere. News Talk 820 WBAP.
In the WBAP newsroom.
You want to weigh in on what we're going to be talking about here? 800-288-WBAP, 800-288-9227. Supreme Court overturns Texas safeguards for women here in the state of Texas. And the 20-week cap, really, on abortions. If you haven't made up your mind within 5 months, you can still abort a child, according to the United States Supreme Court. Let's talk with Byron Henry. He is, of course, one of the legal eagles here on the Chris Salcedo Show. Byron, thanks for being available here at the drop of a hat. Give us your take on what's going on here with this court ruling. From what I've been able to read up in the break, this was a lot broader than I had expected, even if it was going to go against Texas.
Well, there was some speculation that it could be anywhere from a 4-4 tie to a broader opinion, which basically makes it more difficult for states to regulate abortion, not even following current precedent that was laid down about 25 years ago when Justice Kennedy was in a majority that basically set an undue burden standard for laws that regulate abortion or abortion providers. Here it looks like, at least according to the dissent, and just on brief review of the opinion, it looks like the court has gone out of its way to basically make that standard much more difficult for states or others wanting to regulate the provision of abortion at all. They seem to have made the undue burden standard basically a much higher standard for states to overcome, and the dissent accuses them of basically bending all the rules in favor of a woman's right to have an abortion.
Yeah, and exactly. Basically, this is an invention of rights. There is no right to an abortion that's articulated, or the right to take, the way many of us look at it, the right to take a human life, articulated in the Constitution. But it seems that Justice Kennedy, along with the liberals in the court, have invented this right as of this ruling. Yes.
Well, I mean, the right was, so to speak, invented, if you want to call it that, years ago in Roe versus Wade, and it's been Justice Kennedy has been in some majorities to limit the right, such as in partial birth abortion and other restrictions. But it just looks like as of today, there are 5 votes on the court to basically give carte blanche to women, the woman's right to have an abortion, and give very little deference to states and their regulations or any type of rules that affect a woman's right. I mean, we did think there was a possibility that we could have a narrow opinion which basically addressed each one of the states' regulations in detail and upheld some and struck down others. But this was basically a wholesale striking down of all of the state's regulations in House Bill 2. Justice Alito even comments that as part of the collateral damage, there's a provision in House Bill 2 that requires abortion clinics to follow the fire code. And he notes in his dissent that as a result of this decision, that part of the bill was also struck down. So, which he says makes no sense, but that's just part of this controversial issue, and the court members going back and forth with one another.
Well, that was going to be my next question, because now with this ruling, it's no holds barred. I mean, the only recourse that you have now, if you're a woman that goes in, or your daughter goes in for an abortion and is butchered, like Kermit Gosnell or the other nutcase that was here in Texas doing the same thing, you only have, there is nothing to prevent that. So all you have now, there are no standards. It's like, anybody who wants to open up shop and call themselves an abortion clinic, the high court, at least by my initial reading of this, has basically said you can't impose any safeguards. It's hey, women, you're at the mercy of these abortion clinics.
Well, yeah, and it's not just at the mercy of. They're going to, the state had a lot of evidence on one side, and the abortion advocates had evidence on the other side, and instead of taking the state, the state of Texas, the sovereign state's view and presuming the law is constitutional and that their evidence is sound, they basically weighed the evidence and decided that the other side's evidence is better and that there's really no health benefits to these regulations whatsoever, which is what it came down to, is that the 5 justices of the Supreme Court said, we know you're trying to do this for women's health, we know what you're intending to do, but we don't buy it, and we don't think that this enhances women's health whatsoever.
So, in essence, they've said, oh, by the way, Byron Henry is our guest right now. He is an appellate law expert with the law firm Scheef Stone right here in Dallas. So what they in essence said, that a woman's right to terminate her child's life in utero supplants safety concerns, regulations of any kind that any state would be able to impose?
Well, at least safety concerns that 5 justices of the United States Supreme Court won't sign off on. So that's really the issue. And so the state is going to have the court has set a high bar, is my point, on whether or not they're going to be able to regulate a woman's right to an abortion. So a much higher bar than we thought was set by the opinion that was currently in effect as of this opinion. In other words, I believe this changes the standard.
Yeah, so those in the pro-life movement right now are going to have to go back to the drawing board because now the bar has been raised, at least by my estimation, Byron, way higher than it was before. So the way forward, I mean, on what predicate can you place sensible restrictions on the terminating of a human life in utero?
Well, this decision didn't affect the actual viability opinions. The issue in this case was physicians that perform abortions in abortion clinics requirements that they meet certain standards. And so the general rule laid down that the state's interest after viability becomes more compelling and that regulations can be placed wasn't affected by this opinion. So at least for now, we still have the line drawn pre-viability and post-viability. So I would say, to answer your question, there is a lot more a state can do currently, assuming they don't change this rule as well, post-viability, which is usually 20 to 22 weeks, than they can prior to viability. So that
no, wait a minute, because that was a big part of this law was the 20-week cap. They didn't leave that intact, did they? I mean, it's gone. It has been struck down as well.
Well, yes, there's an issue with the cap. That the viability cap, the viability date is in question, whether or not 20 weeks is actually viability or not. But certainly the states can regulate more post-viability than they can pre-viability. The issue would be whether or not they can place an outright ban without exception for women's health and other issues post 20 weeks. Not whether they can regulate the right, but whether they can ban it.
Right. Okay. Well, what many in the conservative movement will look at as a major defeat at the high court, 5-3 decision. Kennedy siding against conservatives and against the unborn in his joining the majority of liberals on the court in striking down the Texas abortion law. Byron Henry, everybody, appellate law expert with the law firm Scheef Stone. Thank you for, again, Johnny on the spot, for being here and available to evaluate the decisions coming down from the court the last couple of days.
You're welcome, Chris.
Thank you, sir.
In a ruling today, the Supreme Court threw out provisions of a Texas law regulating abortion clinics. The majority opinion held that the regulations are medically unnecessary and unconstitutionally limit a woman's right to an abortion. Legal expert Byron Henry says a decision means the court found no health benefits to the Texas regulations. 5 justices of the Supreme Court said, we know you're trying to do this for women's health. We know what you're intending to do, but we don't buy it, and we don't think that this enhances women's health whatsoever. Henry says the court's ruling has now set a high bar on whether or not a state can set regulations on an abortion.